Hi guys, sorry, I'm Dominique. I'm the social worker here at Changes Rehab. And, this is a bit of a, it's a bit of a tricky topic. This one was a bit of a soft topic, or like it kind of might kick a nerve for some of you, but I feel that, this is a topic that's really important, to discuss generally in the beginning of the year, just so that you as families understand what options are available to you if you should ever need them, and obviously how the process works and how you can go about doing a court order if that's something that's necessary to help your loved one. Kate, you can go to the next slide, please. Okay. So as an introduction to what a court order is, there's a law that is currently held in South Africa that allows for a person or persons to have someone involuntarily admitted into a treatment center facility for drug and alcohol rehabilitation. It's generally known as a Section 33. That's sort of the abbreviated term for it, or the term for it, or you can just call it a court order. And what that law allows is that any qualified person that can, send a request to the court can order someone's loved one into, sorry, hang on. So the law is for any qualified person to make a request to the court to have someone that is a danger to themselves, to their loved ones, and to society. It's under the Prevention and Treatment of Substance Abuse Act 70 of 2008. I'm not going to go too much into the nitty-gritties of where it is and what page it's on, because it's a very big act, and it's got quite a large sort of coverage. So specifically what I'm going to focus on in terms of court orders for people with addiction is that, how does the process work, and how do you go about doing this for your loved one? So with a court order, what happens is that the magistrate is generally looking for three main factors, and that's they're trying to see or prove, or the state is trying to prove, that this person is a danger to themselves, i.e., using drugs, self-harming, driving under the influence, any kind of that, those factors could play into that. If they are a danger to their loved ones or others, so if they're getting aggressive with family members, if they're threatening to kill family members, then that kind of plays a role. And then also if someone is a danger to society. So if your loved one is stealing or committing any sort of crimes or anything like that, then they can fall into that category of possibly getting a court order for them. Next slide, please. Okay. So when we look at the Act itself, what we generally focus on is that Section 33, and then there's a Section 35. So what that does and how that works is, if an involuntary user may not be provided with, an involuntary service user may not be provided with treatment unless a sworn statement is submitted to a public prosecutor within the area of jurisdiction of the magistrate's court. So what the court is generally looking for is some form of affidavit, that can be submitted to the court, requesting that you want your loved one in treatment for an extended period of time because of the following reasons. It has to be within the jurisdiction of the court where they reside. So it's not just as simple as going, excuse me, sorry, my voice is disappearing. It's not as simple as going to any court and just requesting the stuff. It's a simple process. I always say that it's a simple process, but it can be quite complicated because we are dealing with the justice system. So generally you would go to a magistrate's court within your jurisdiction of area. For example, Changes falls under Johannesburg, so we use the Johannesburg court, because if it's outside of the jurisdiction, the magistrate won't be able to assist you. Is a person who is dependent on substances and is a danger to themselves, causes a major public health risk, does harm to their own welfare or welfare of a family and friend, or commits a criminal act to sustain their dependence on substances. This is essentially, what I mentioned previously as, if your loved one is getting aggressive, if your loved one is completely uncontrollable, if your loved one is committing crimes and getting arrested, then then this is something that you may need to look at. I always say that a court order, court order is generally something that happens in a crisis. So what we find is the family is in a crisis mode. They don't know what to do. The person doesn't want treatment. The person says they don't have a problem. There's a lot of denial. And then what would generally happen is the quickest and easiest way to get someone into treatment is through a court order. If you're unable to get the person to commit themselves willingly. We also use it as a tool, once your loved one is in treatment and they need extended care but are refusing to have extended care. This is a process that the family could follow, to try and help save their loved ones' lives. Next slide, please. Okay. When we look at the aim of the Act, it's obviously there to provide a national response for combating of substance abuse. So it's something that can be used through the courts, to try and minimize the effect that substance abuse has on the community as a whole. It provides for registration and establishment of facilities. So what that does is when we generally have to court order someone into treatment, it has to be a registered facility. With the Department of Social Development. There's a lot of, and it makes me quite angry that there's a lot of sort of fly-by-night treatment centers that, they aren't correctly set up. They haven't got the necessary certifications. And they actually, they might be more affordable, but they do not provide the level of care that someone with substance abuse would need. So what the Act does is it actually ensures that the treatment centers that people are being sent to are fully equipped and fully registered. It also provides for the committal of persons to and from treatment centers. So what happens is that, they can sort of chop and change between centers, but as long as they're registered, there's multiple reasons why this could happen. I'll get into that a bit later. And then it also, it's used to helping families get the necessary assistance for their loved ones. Like I say, we often talk a lot about tough love, and we often talk about, setting very firm boundaries with your loved ones. And I always say that this is the family's absolute last resort, to try and save somebody's life. It's not a smooth process. It is an incredibly taxing, emotionally taxing process for the client and for the family. But this is a very set, firm boundary that a family could set with their loved ones in order to save their life. It's not something that someone takes lightly. But if you've got someone that is fighting and someone that is causing absolute havoc in your life and creating absolute destruction, this might be the best option for you to look at so that you as a family can also heal. Because what the order does is it'll place your loved one into treatment for long term, and that gives you as a family an opportunity to also heal, because at least then my loved one is safe, my loved one is in a safe space, they're getting the treatment that they need, and now I can take the time to actually relax, well, mostly relax, and then try to, just work on yourselves while your loved one is getting the assistance that they need. Next slide, please. Okay. So we're going to also look at who can have somebody involuntarily committed. Don't know why the slide is doing that. That's so weird. So basically any person can request to have someone involuntarily committed into a treatment center. But the application that goes through the court is either done by, a police officer, a social worker, a spouse, a blood relative, a guardian, or a court official. So I often say even family friends can also put the application forward. It's not on that list, but if, say, for example, your loved one has burnt all their bridges and there's some distant friend down the family line that's known them for however many years, wants to assist this person to get into treatment, they can also apply. But when it comes to the application, there's two ways to go about it. You can go through the police, but I don't know how successful that would be. You can go directly through the police. They can assign you, or put you in touch with a social worker that can assist. You can go to the court directly. However, this does take quite a substantial amount of time. It can take anything from 2 to 3 weeks up to 8, 9 months if it's done through the court directly, because obviously, you know, we all I joke, we know the justice system, it's kind of how long is a piece of string. So you can apply for it yourself, but the problem with that is when you're going through the state, it takes a lot longer, and it's also about, you know, making sure that there's beds available at government facilities for your loved one. If you do it privately, it can take a lot quicker. So it's always just dependent on how, and generally, because it's such a crisis in getting someone into treatment, you want it done sooner rather than later. Next slide, please. Okay. So we're going to look at a little bit at the process and how the family is involved in this process. It's quite a complex, it's a simple process, but it's a complex process. So when I say simple, it's just a matter of, you know, submitting documents to the court, and then they would give us a date to appear in the court. And it sounds easier than it is. So what we generally ask for when we're going into a court order, when I'm specifically doing a court order, there's an affidavit that needs to be presented from the family member or from a friend or from someone that has experienced this person's behavior. And what we normally do is that affidavit is generally, it's not a one-pager. It needs to be quite detailed in the sense that this is the person's history, this is how long they've been using for, you know, if you know what substances they're using, you need to include that in the affidavit. If they've ever been arrested or committed any criminal acts, that needs to be included. So it's essentially a summary of your loved one's life and the process of their addiction, and also how have they affected you as a family member. These affidavits are very difficult to write, and they're very difficult to put together because it is very emotionally taxing. As I said, you know, the family often have to bring up a lot of past events and a lot of stuff that hasn't sat well with them. But unfortunately, you know, when we bring the application before a magistrate, we want as much evidence as possible, because the magistrate needs to see that this person, okay, you're a danger to yourself, you're a danger to others, and you're a danger to society. What then generally happens is a social worker such as myself will base a psychosocial report off of the affidavit that is presented by the family member. And then we work off of what we see or what we feel we see, you know, within that affidavit, and obviously through interviewing the family, we get as much information as we can, and we put together a psychosocial report. We would need a confirmation of bed letter from the treatment center where you wish to place your loved one. You know, doing it privately has a lot of perks, as you can obviously get them into a treatment center of your choice, you know, which makes the process go a lot quicker. And then what we generally do is we say, okay, the rehab has a bed available. Obviously, we need to include the registration certificate of the rehab, because the court will not order people to facilities that are not registered. And then obviously, if there's any medical certificates that can be provided to the court, that would be extremely beneficial. What then happens is these documents get submitted to a prosecutor, usually the senior prosecutor of the state, that handles the rehab. They call them rehab inquiries, and then they'll give us a date to testify. The next question I get a lot, or very often, is how do you get your loved one to court? Because they're not just going to wake up one day and say, okay, let's go to court, get in the car, and off they go. So there's two ways of getting someone to court, and this usually creates a bit of panic for families, because it can be quite intense, and it can be incredibly stressful. So the two ways of getting somebody to court is either through a summons, where they get issued with a summons and they have to appear in court on a certain date. They need to sign it. They need to be at court on that date. That one is a little bit tricky, because when we're dealing with someone who's involuntary and doesn't want to get treatment, they're not just going to sign a summons and appear in court. So what would then happen is I would get a warrant of arrest for your loved one. And then obviously when I say warrant of arrest, everyone panics. The most important thing for you as families to understand is that arrest is not a criminal arrest. It's not an arrest that will, give your family or your loved one a criminal record. It's just an arrest to give the police permission to escort your loved one from their place of residence to the court to appear before the magistrate. So this act is set up in such a way that it does not create a criminal record for your family or your loved one. So yeah, that's basically the most important thing for families to understand, because when I usually say warrant of arrest, people are like, no, we don't want to do it. So it's very dependent on, the situation. If like for myself personally, if I'm picking up the person from their house and we don't know what kind of situation they're going to be in, I usually prefer for us to come with a police escort, because we don't know how the person is going to react. And then once there's a date that's been given and we have to appear in front of the magistrate, we get what we call opposed orders and not opposed orders. So the not opposed orders are generally the easy ones, because your loved one's not going to fight. They'll throw up the white flag. They'll say, okay, I surrender. I'm not going to fight this. I'll take whatever happens. And those usually go a lot quicker. If we have an opposed court order, that means that your loved one is going to kick and scream right till the very end. They will come up with excuses. They will argue with the magistrate. They will insist on lawyers. There's usually quite a few postponements involved. And generally, most of the time they are opposed. However, there's sections in the act that will allow for your loved one to be placed in the custody of a treatment center while awaiting the finalization of their court date, so that you as a family don't have to worry about them coming home and causing more chaos. Next slide, please, Kate. Okay. So most importantly, I want to look at the reason. A court order is a very, very stressful and large process for a loved one or a family member to go through. But I often say, to families that if you do the court order, then at least you know yourselves that you have done absolutely everything in your power to help your loved one. If it doesn't work after that, then at least you've tried everything that you can from your side. When we look at the reason, serious harm is defined as a substantial risk of physical harm to the person, himself, herself, as manifested by evidence of threats of or attempts at suicide or serious bodily harm, or a substantial risk of physical harm to others as manifested by evidence of homicidal or other violent behavior, or evidence that others are placed in reasonable fear of violent behavior or serious physical harm to them, or a very substantial risk of physical impairment or injury to the person as manifested by evidence that such person's judgment is so affected that he or she is unable to protect himself or herself in the community, and that reasonable provision for his or her protection is not available in the community. That's basically sort of the definition of all the reasons and the explanations that I'd given to you before. When we look at people in active addiction, there's a lot of chaos. There's a lot of distraction. Everyone is getting hurt. It's not a nice place to be. And the reason is that if they continue with the behavior and the substance abuse, the likelihood of them dying is very high. Whether it be in a car accident, whether it be in a gang fight, whether it be from an overdose, if your loved one is in a situation where they just cannot control themselves and they can't make rational decisions for themselves, the addiction would likely lead to their death. And that is why court orders are so important, because you can actually get someone the help they need for a long term before it's too late. And when we look at the reasons that someone would need to be involuntarily committed, it's as we said, serious risk to themselves, serious risk to others. Again, it's often that crisis management of just, I need my loved one in treatment and I need it done now. And then, it's like that crisis control of getting them into treatment as quickly as possible. The Act only provides provision if it's directly related to substance abuse. So it would have to be drugs or alcohol. And then there would have to be sufficient sort of evidence to say that there would be, medical doctors that would stabilize their medication, get them sort of under control. And then obviously, like I mentioned, it's about making conscious or rational decisions that your loved one won't be able to do when they are in active addiction. Next slide, please. Okay. So where do we think the family fits in this situation? So it's, again, as I mentioned earlier, if your loved one is in treatment, but you don't feel that they're ready to come home, you can implement a court order at any point of their treatment process. As I mentioned as well, it's the desperation. Like, I need to save my loved one by whatever means necessary. And like I said, it's generally the last resort because you've tried everything else and nothing else has worked, and you're desperate to get your loved one into treatment. The family will be full of a lot of fear for their loved ones, like, what is going to happen if you don't get treatment and you don't get better? Are you going to die? Are you going to kill me? Are you going to rob me blind? Again, it's also when there's been many failed attempts, multiple rehabs, none of them have worked, lots of short-term treatment facilities, then it might be worth looking into a court order. And then, as I mentioned, it's the tough love, but also it's to keep your loved one in a facility so that you can also heal, because addiction is a family disease. It doesn't just affect the addict, it also affects their families and their loved ones. And if you know that your loved one is in a place of safety for some time, you guys can start to heal as a family as well, because you don't have to worry about them and you can start healing yourselves. Next slide, please. Okay. So we'll look a little bit at the pros and cons. So yeah, like some of the pros of doing court orders is that you can guarantee at least 18 months of sobriety, which will allow the brain to rewire itself and heal itself. And it also gives the substance abuser more time to grow a strong foundation in their recovery. It does take the brain at least 12 to 18 months to heal from addiction. There's a lot of chemical imbalance that needs to be balanced out. And the longer you can keep them off the substances and in a program of treatment program, the better their chances of actually staying clean and sober, because you've tied them into a program of recovery for so long that it almost becomes habitual and they can start making those rational decisions. It also, as I mentioned, gives the family a sense of relief so that, my loved one is safe, getting the help they need. I can get the healing and the help that I need. It allows for relationships to rebuild themselves and it allows time to heal. Next slide, please. Okay, the cons. Like as much with anything that comes with pros, there's always cons as well. So, you could go through this process and your loved one is still not going to want to get the help that they need, and they're going to be very unwilling. Your loved one will be angry with you. Sometimes for some time, they are going to hold grudges because they're going to feel like they're being punished when you take them through a whole court process. So they do tend to hold grudges, but those grudges can be processed and worked through with their therapists in therapy. They feel like they're being locked away. They feel like they, aren't giving sort of their freedom, and they my favorite line that always comes is like, but I'm an adult and I have rights. And that's it, and I say, once the court order is in place, that person doesn't have those rights anymore because they have, they've been placed under an order to stay in treatment to get better. So it can cause a little bit of rift in the family. Sometimes it carries a lot of guilt and shame from the family side because now, my loved one hates me because I did a court order and stuck them in treatment for 12 months. but that anger does dissipate. So the more they work and process it through therapy, and the more they work on their program of recovery, they will start to understand why you did what you did. They'll start to see it clearly, they'll start to understand it, and they'll sort of start to realize, okay, you did this to save their life. There is another con that I haven't mentioned on this list, and that is that, even though the court order doesn't give them a criminal record, if they choose to run away or abscond from treatment, a warrant of arrest will be placed out for them in terms of breaking a court order, and then it becomes part of the system, and the system then decides what would happen to them thereafter. We haven't had many of those cases because generally your loved ones will get court ordered and they will comply. We haven't had much issues with people wanting to leave and running away. Next slide, please. Okay. Like I say, in terms of you as a family, you might feel a lot of guilt and shame around doing the court order, because once again, it's a massive process. It's not a small thing. It's you get to a point where a court order is the only thing that's going to work, but you might feel some guilt and shame around it in terms of like, am I doing the right thing? Should I have done this? Now my family, my loved one hates me. But I think that guilt and shame is okay. It also stops enabling behavior. So it's a very, very tough love, firm boundary that you can set with your loved one, saying you will stay in treatment for this long. If you don't, these are the consequences. So, and it'll just stop that. It'll stop family members and loved ones, because this happens a lot of the time where a family member or a family member of the loved one or the addict might enable the behavior and try and get them out of their consequences. So this is something that says, I'm done now, I'm doing this, and you're going to treatment. And then there'll be quite a bit of anger towards each other and some animosity. But like I said before, this is kind of the stuff that would be processed through therapy with their counselors and their therapists. Next slide, please. Oh, okay, that's it. All right, so yeah, I know this is it's a bit of a tough topic, but it's something that, like I said, I like to do it sort of at the beginning of every year, just so that you as family and loved ones, understand that this is an option available to you, and that it's something that you could look at if you needed to. So I'm going to open it up to the floor. If anyone has any questions or answers, or if anyone would like to share their experiences, if you've been through this before, and then you can just raise your hand and I guess go for it, or you may leave us a message in the chat box.
Well, Dom, since it's you and I for now, I actually do have a question.
Go for it.
Yeah. So yeah, obviously the court, from what you said, I understand the court will decide how long the person will stay in treatment. Is it possible for the family to reverse that process, or to, take back the request for the court order once it's already been in place?
Not once it's been in place, no. So a family can withdraw the order at any point up until the magistrate has actually said, you will go to treatment for this long, stamp the paper, order's done. The client, or what we call the respondent, which would be the addict, would be able to appeal for that court order within a period of 2 weeks after it's been issued. But once the order is in place, it's very difficult to get out of it. Something that I also forgot to mention, just before I forget it again, is that unfortunately with the court order, because your loved one is over the age of 18, they do need to appear in court in front of the magistrate, as they do obviously have rights as a human being. So they can either, they can contest the court order, they can request a lawyer, They can defend themselves if they want to. Usually the magistrate doesn't like that though, but it is, that's where it sort of becomes a little bit more difficult, where we can't just take them to court, stamp a piece of paper and put them in rehab. So sometimes there is a bit of a fight involved in that process.
I have another question.
Go for it.
Are there any cost implications for getting this whole process going?
Yes. So if you go through a private social worker, there generally is a cost implication, because it's not so much the court appearance that's the problem, it's the paperwork and all the back end work that goes into it. So it does unfortunately take a lot of time to put together. So there would be, and then obviously dependent on the treatment center that you put your loved one in, what are the cost implications there? Because if you're gonna, if you're putting your loved one into a treatment center for a long period of time, obviously medical aid only covers so much, but I mean, these arrangements, can be done and had, with the facility where you would like to place them. No, I mean, because that's why, like with me specifically, I don't give families an exact timeline as to when it's going to happen or how it's going to happen, because, when we're dealing with the South African justice system, you never know. You never know if you're going to be lucky and get a date like the next day, or if you're going to have to wait 3-4 dates for a date. And I think it's also in terms of that, it's also I'm not sure if you did back then, but it's also about, sort of looking into the social workers that are saying that they can do it, because some people will say they can do it, but they actually don't know the process like as well as some other people do. That's just what I found from my experience when, when I started out with this, is it's you've got to know the right people, you've got to know the right place to go. It is very, and especially in Joburg court, it's massive. You can get very easily lost in there. So yeah, but I think I like what you say, Merle, about keeping the paperwork just in case. It's always good to keep around in case you ever need it again.
You mentioned something about medical aid. So if the court orders a person to be in for a year, for instance sake, is medical aid able to cover that first initial 21 days and then obviously make a plan for the rest of the time, or how does that work?
Yeah, so look, medical aid will cover what medical aid will cover,
okay.
which drives me mad because it's never enough. But anyway, medical aid will cover the first 24, 21, 28 days. And then generally, I know that what happens is that a discussion pre-court order is had, just in terms of, okay, what is the family's financial stand? What can they afford? When we often put someone into treatment for such a long period of time, we are obviously very cognizant that we don't want to put the family out of house and home as well. So, we do have those conversations pre-court order to just establish, okay, are there funds? What do the funds look like? What does the financials look like? So that before we go through with the process, there's a plan, and we're not just putting someone in treatment for 12 months that can't be paid for, if that makes sense. So those conversations always happen pre-court order.
Okay.
Do you have any more questions?
I do, actually. Yes, my question was about the paperwork. How long is that paperwork valid for? I assume some of it is dated. And this is obviously pre-going into court, because you date your affidavit. Do you not? Yeah.
Yeah, look, affidavits are generally dated. So if we don't go ahead and say we wait 8 or 9 months, I usually recommend to the family to keep the same affidavit, just change the date, and then I would change the date on my report just so that it's a bit more recent, as opposed to just hanging on to something for like 4 or 5 years and then hoping that it will, because I usually, in terms of the affidavit, I ask the family to actually type it out onto a Word document and then get it certified, because there's so much information. I can't expect a family member to sit in the police station and write like 10 pages of affidavit. So I normally send a format through to the family, they edit it, they fill it in, and then they get that certified, and then the date can always be changed if it needs to.
Okay. Yeah.
Actually, there was something else that I wanted to mention that's kind of just popped into my head now. So, see, it's a very complicated act with lots of pages and lots of things to remember. But basically what happens when someone is court ordered into treatment, the law says it's for a period of up to 12 months. And then what they generally say on the order is that until such time, the respondent, which is the patient, is either released on license or transferred to another facility. So, you know, it's quite nice because it gives you that room to play. We always say go with the 12 months because at least you've got the room to play. And then if at any point, you know, because I think specifically our goal at Changes as well is, you know, we don't want people to become institutionalized. We want people to get out. We want people to recover. We want people to live their lives and become successful, you know, so we aren't going to keep someone for longer than they need to be here. So you know, if the person, say, is doing exceptionally well and they're like on 8, 9, 10 months of their treatment plan, you know, we put a treatment plan in place for the remainder of the 12 months and then we take it from there. But, you know, we always say to the families, go for 12 months because that gives you the most, I don't want to call it leeway because that sounds wrong, but it gives you the time to make sure that your loved one has got an effective plan for before they leave treatment in order to go and, you know, be successful and live their lives.
Yeah. Okay. We have a question.
Once a court order is issued, can the rehab center prevent that person leaving the facility, or is that the jurisdiction of the SAPS? So, look, obviously the treatment center will do whatever they need to try and keep your loved one in treatment. As I mentioned earlier, you know, we haven't had many instances. I think, like, in my entire career, I think I've had like 2 that have run away. Because, you know, generally when someone is standing up in front of a magistrate and the magistrate has said, you have to go to rehab or else, you know, people will kind of submit and comply. Like, and I mean, like I said, any kind of inclination that's like, if someone wants to leave, then we have to call the police, report that person as absconding, and the police then need to assist us in terms of having them arrested and taken back before the court or brought back to the treatment center, you know, which can sometimes be a bit tricky, but, you know, they're normally quite good at responding. But like I say, I've been doing this for 3 years now, and I've had, in my 3 years, I've done many, many, many court orders, and I think I've only had 2 run away. Like, and I've done many, because like I find most people in their right mind don't want to go to jail, so they'll actually comply and do the program and do what they want to do. But if they do abscond from treatment, then generally we would report it to the courts that they've run away, and then we would report it to the police, and then the police would have to take over from there. I hope that answers your question.
Before we close, I have one more question.
Go for it, Lolly.
Yeah. Is a court order in one place, or is it through phases within a treatment process?
So it can be either or, depending on the treatment center.
Okay.
I prefer to do it in phases, so they're not stuck in like a primary care facility for a year, because I feel like that would make people, like, that would make your loved ones feel like they're in jail, they're in prison, they're stuck, they don't really progress in their progress. So I prefer to, within that year, we work on phases of treatment so that we can actually start reintegrating people back into their lives, as opposed to just keeping them locked up in a facility for a year.
Okay. We have another question in the chat room. If our loved one is willingly agrees to stay in the treatment for a year, then is it necessary to get a court order?
No, I don't think if your loved one is willing and they've agreed to 1 year, then I wouldn't go through that process, unless the treatment team feels that this is something you need to do in order to hold your loved one accountable because there's still behavior or whatever. But if the person is willing, then I wouldn't put yourselves and them through that process unless you absolutely have to.
Okay, I think we've got time for one more question before we close. If there's anyone.
Here's another one.
If you're under,
sorry,
go for it,
Lolly.
Dom. No, go for it, Dom.
Yeah, no problem. If you're under court order, you're allowed to go to a halfway house. Yes, you can, as long as, because as far as I'm aware, that there would be a little bit stricter rules in terms of, what you can and can't do in the halfway house, but you would be allowed to move into a halfway house as well. So in a sense that, look, you would be allowed to go to work, you'd be allowed to do what you need to do, but you'd have to be held accountable by the treatment center. So like regular check-ins, regular drug tests, continue with counseling sessions, just to make sure that you are doing what you need to do and not disappearing. I hope that answers the question. Basically, in a halfway house, you're just a little bit more, if you're on a court order, you're a little bit more cushioned than everybody else, because obviously we have to make sure that you don't do anything that you shouldn't be doing.